Okay, let's start back up. Obviously, keep eating. By the way, there's seconds if anybody wants one, or you want to you want to take one back for dinner tonight or something. Grab one. They're sitting there. There are 22 states in the United States that elect judges, and Texas is one of those. And we have partisan elections. Today, what we wanted to do is show you that this issue of interpreting the law and how you interpret foreign law is not a partisan issue. We have both a Democrat and a Republican judge here to talk about that and to share with you how these issues come before them. We wanted to give you some real life examples of how they look at issues involving foreign law and how they address them on a regular basis in their courts. And so I'll turn this over to Judge Henry and Judge Garcia now.
Go ahead and keep eating. And if you munch real loud and don't want to hear me, that's fine too. But thank you so much. You know, I was kind of visiting with my wife the other day. We had got away for a couple of days, and we were talking about things that we like. And we said, we really like baseball and politics and law. And I think the reason that we like those things is because in each area, everything is sort of interrelated with one another. I mean, you know that in politics, you can sort of move something over here, and then it will affect something way over here. And that's sort of a good way to think about this whole topic of jurisdiction and foreign law and things like that. That if you touch something here, then you have inadvertent consequences or unintended consequences of something over here. From a judicial standpoint, the first observation that I have is that as judges, we take an oath to follow the law and follow the Constitution, and that is something that we take very seriously. The concept that we don't take anybody's property unless there's due process. We make sure that there's procedural and substantive due process. And every decision we make is seen through that lens. And so you always have that protection of the oath that we take very seriously. And when you're talking about this subject, the thing that has been kind of rolling around in my mind for months is the concept of you're a legislator and you go back home and you have to deal with a question from a well-meaning constituent. How do you really answer those questions in a very short amount of time? And I think there's a number of ways to do it, but I think the first and easiest way to do it is to think about the concept that this is all about jurisdiction. When we untangle jurisdiction, whether it's foreign court or another state or anything of that, when we take that act, then that means that once we go over the state line, once we come into Texas, it's just sort of the Wild West. There are no rules that apply. I kept thinking of that line of, once you cross that old Red River Hoss, it just doesn't mean a thing. And that's sort of what you have when you tinker with jurisdiction. Once you get into Texas without jurisdiction from another court, then it's the person with the most power, the most authority that can grab a child and do whatever. And that's an important concept. The other thing is, the other effect that it has is that you have a situation where you subject the child to continuous and consecutive litigation if you have no jurisdiction when you come into Texas. And that's not a good thing. That's something that we need to take very seriously. And I understand we're very early in the process, and I'm not here to advocate a position, but by the same token, it's something that has really kind of hung around in my mind since I've been thinking about this topic. Also, we have the UCCJEA, the statute that you've heard about this morning, the Uniform Child Custody Jurisdiction Enforcement Act. And what's interesting about that is that's the law in 49, if not 50 of the states. And once we tinker with jurisdiction on one hand, we tinker with UCCJEA, and it puts Texas outside of the mainstream. Now, we're Texans and we're unique, we're the best, but by the same token, it's probably not a good thing if we are outside the remainder of the states when it comes to child custody. How many of you are familiar with that Ashfac case? Is that something that's any part of your discussion at all? Ashfac was a case where what happened is that a couple were married in Pakistan. Then they came to Houston and they tried to get a divorce. As they were proving up their divorce in just kind of the standard way that you would in a Texas court, they hesitated and they said, well, wait a second, I thought we did this back in Pakistan. It turned out that they recessed the case, and it turned out that they had followed this procedure in Pakistan. And generally speaking, according to the case, I'm not an expert on that, but according to the case, the way someone gets divorced in Pakistan is that usually the husband says, I divorce you 3 times, and then they present that to the tribal elders, and the tribal elders make that a final decision. So this couple, the Ashfac couple, comes back to Houston for the second time and tries to prove up this divorce. And they said, well, we're going to generally apply this this law because they were divorced in Pakistan. And that's kind of raised a lot of issues and a lot of questions. But if you really think about the case, there's a couple of things that are incredibly important about it that you really don't catch unless you really think about it. The first thing is that the way in Texas courts that foreign law is presented to a judge is through Rule 203 of the Texas Rules of Evidence. And in the Ashfac case, it was not done through Rule 203, it was done through 702 of the Rules of Evidence, which is basically the expert testimony. So what happened is the lawyers did not object that this procedure was done this way in Texas court. Normally, if there had been an objection, this case would not exist. The second thing is, what's the problem with this Pakistani procedure? The problem is general potential due process, the concept that someone may have lost their property without real due process. In the Ashfac case, that issue was raised in the appellate court, but it was not briefed. It was not argued. If you go back and look at those briefs, they say the magic words, but they don't go into it in any detail. So if they had briefed that case properly, I believe the situation would have been a little bit different. The third thing is, it kind of seems like there's this procedure, that is, the magic words, I divorce you. In Texas, we have magic words also. In order to get a divorce, one side has to say, our marriage has become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation. And then it's presented to a court that after 30 days it becomes final. So I think as we think through the details of Ashfac, then it is not necessarily as clear as you might see. The other thing is that if you really look at that case, they did not really even follow the procedures of Pakistani law, but that issue was not raised in the trial court and could have been, but was not also raised on the appellate court, at the appellate court. So bottom line, what we have is, we have a situation with jurisdiction that's all related to one another, and we have a situation where Ashfac may not be the case that you think it is on the first reading of it. And so that's something to think about as you make these decisions. And I just want to say a personal word. I don't get to the legislature very much, and it truly is inspiring as a citizen to see people who will come in and spend the time on a very difficult, complicated issue and work through this with us. So I'm very appreciative of you being here and very appreciative of getting an opportunity to visit with you.
Thank you, Judge Henry. Just to go in a little bit more detail about Rule 203, if somebody intends to, sorry, I probably hit your microphone. If somebody intends to raise an issue about a foreign country's the law, they must give notice by pleading or other writing. That is 30 days before trial. They have to supply all parties a copy of any written materials or sources the party intends to use to prove the foreign law. So they have to give you notice that they're going to use foreign law. Then the opposing party has the opportunity to counter with any material or source to the court within a certain time frame. After that, the court may utilize any source necessary to try and determine what the law is. When the judge makes a decision, a determination as to what the law is going to be, their decision is made as a matter of law. That is, it doesn't go to a jury. It's decided by the judge. And then, of course, that's subject to appellate review. So we have systems in place that help us figure these things out. The other thing to remember about ASHFAC is that Texas property was not divided in Pakistan. Texas property was divided in Texas. Notice was provided to the wife. She did not participate. And again, that's the same as divorce jurisdiction in Texas. We can grant a divorce of a person who resides in Texas and has met the residency requirements without having someone else, their spouse, in Texas or even having jurisdiction over that person. So I think that's the distinction that you need to have between Seth and ASHFAC. There are also provisions for translating foreign language documents. It's the same thing as Rule 203 relating to submitting that translation, except it's 45 days to submit the translation. And you know, if you speak a foreign language, you know sometimes something gets lost in translation. There can be the opportunity for different interpretations of what something says. You have that in English. That's why we have two sides in lawsuits, is we can all be agreeing on this is the law that we're going to use to resolve this dispute, but we have different ideas of how that gets translated. Let's see. In the absence of adequate proof, when we are relying on experts, the parties can bring their experts in, and based on what the expert says, the court can make a ruling on that. So to recap about what we have today before us, foreign law happens. We've been dealing with foreign law for centuries. We have a way to deal with it. It's called comity. Comity is a way that we reciprocate and understand each other's laws so that we don't have chaos. We have the understanding that comity is not an all-binding straitjacket on us, that we have limits to comity. Some of those limits include jurisdiction. And in family law, there are 4 to 5 different kinds of jurisdiction that you can have. You can't say, we're just going to make this big umbrella rule about jurisdiction because it's an entire, I spend 2 classes on it in family law, and that's just the bare minimum. It takes years of lawyers working through this to try and understand the full repercussions of how you apply jurisdiction. There's public policy. There are little tricks and balances all through the family code that establish what public policy is and guides us for that. There's the ability of people to contract on their own to decide what's best for their families. And then after all of that, we still have our basic fundamental rules of Texas Rules of Evidence, our rules of civil procedure that help guide us in presenting foreign law and then making a decision of how it applies. If there is a final question about whether or not foreign law should be applied, nobody knows what foreign law is, here's the final presumption. We assume they act like Texans, and we apply Texas law. So we have all these little fail-safes that exist through the system that we really enjoy as as people who make decisions and as advocates. If they don't know the rules, they learn about them in their preparation for the case. I think at this time, we're probably toward the end of our, of what we have. Did you have anything else to add, Judge Henry? No. Okay.
I had a question.
Go ahead.
You had your case on, that involved Bangladesh.
Yes.
Can either of you mention a case that you've had in your practice when you've been on the bench that addressed foreign law, where you had to look at a specific foreign law issue?
I've been on the bench 12 years, and it all starts to run together. I know I've come into foreign law issues, but they've usually just been so tangential to the entire case that they weren't dispositive of the case. They were, but for example, one that I recall is a marriage in India. Did the marriage happen in India? They had gone through their ceremonies in India. They came to the United States, and like not most people, but like a lot of people, belt and suspenders. They wanted to make sure that it was going to be valid here, so they had a formal ceremony in the United States upon entry to the United States. And so then the question became, when was the beginning of the marriage? Was it the time they had the religious ceremony in India, which would have been, depending on who you believed, would have been a ceremony that was recognized in India? Or do you make the beginning the time they'd had the formal ceremony in Texas? Now, I know you might think, well, why don't we just go with the formal? Well, in Texas, we have common law, okay? So to the extent that the parties disagreed on Indian law, and maybe the balance was tipped in favor of marriage because it was a religious ceremony, they intended to be married, it was overweighed by my training in common law, Texas law, which is to say, if the parties agreed to be married, they resided together as husband and wife, and they held themselves out as husband and wife. That even though they weren't in Texas at the time, they had the religious ceremony, maybe a question on whether or not that was a marriage, but definitely under Texas law that would have been a marriage, except that those things have to happen in Texas. So that's the kind of thing that where you hear the expert testimony, you make a decision, and then you're just kind of reinforced by your training already in Texas law. Judge Henry.
Do you have that?
I haven't had one, because, think about how unique this is. Think about how unique this is. A lot of very specific things have to happen. There has to be multiple potential marriages in multiple different places. And so it is a rare event. Now, oftentimes we will divide property that is in Mexico or things like that, but that's generally a very easy process, so to speak. So we do not have a situation, this whole area of law does not come up on a day-to-day basis.
Oh, and I did have something to add about the Mexican divorce. I think Mr. Webb had talked about, or the Mexican wedding. Don't go off and get married in Mexico because it can complicate things. Both on both ends, marriage and divorce. There are marriages that happen in Arizona and in Louisiana that are under quite just a little bit different terms than we do in Texas. They're called covenant marriages. Okay, they get married with the idea that there's only going to be a divorce under fault grounds, that you can't have a no-fault divorce. Somebody moves to Texas, they meet the Texas residency requirements. Texas, despite full faith and credit, despite rules of comedy, Texas doesn't have to recognize that covenant marriage. So to the extent that you reach other agreements when you get married, depending on what those agreements are, Texas doesn't have to honor them. And again, we're using our Texas training, our Texas laws to guide us in deciding whether or not we have to recognize those agreements that are reached at the beginning. Now, on the back end, divorce in Mexico, people talk about a quickie divorce. Those happened as a result of the fact that you had to have fault in the States in order to be able to get the divorce. So people would go to another country, go to Haiti, go to Mexico, whatever, where they could get a quick divorce and come back. A lot of that has dissipated because now we have the magic words, My marriage has become insupportable because of discord or conflict of personalities that destroys legitimate ends in the marriage relationships and prevents any reasonable expectation of reconciliation. See, those are the magic words, and every family lawyer in Texas knows them. I have my law students, that's one of the questions that they have to memorize, no-fault divorce, because it's so common now. So that's less of a problem than it used to be, but, that's what I had to add about this.
Thank you.
So if we passed the covenant marriage in Texas back whenever the push was, all you would have to do is go to another state and you could have gotten a no-fault divorce.
Exactly.
Okay. Now I'm just curious because,
How it's set up, that's right.
That's actually law throughout the land, and we have full faith and credit, but that's not one of the things that's given full faith and credit.
Thank y'all.
I'm going to, real quick, go to the question that you had asked a minute ago, and that was the question about whether, what the other side says when we're talking about all this foreign law issue. And one of the things, on the packets that you had on your table, after you see the information on the Texas Family Law Foundation, you'll see some documents that have at the top of them Islamic Tribunal, okay? And if you were to Google this, because everything is true on the internet that you find there, you would find several stories about where people are saying there are Islamic courts in the state of Texas. We have Islamic courts that have been established here, and that it's going to spread throughout the entire state, and we're going to have two systems of justice, and that simply isn't true. And so in an effort to try and provide some education on this, the same is true also for other means of conciliation and other means of mediation and other means of arbitration. And so in an effort to provide education on this, we're going to close with a question and answer session and some discussion with three individuals that are involved in religious arbitration, reconciliation, and mediation. And this morning, I had named those individuals, but I'll invite them to come forward, because we wanted to make sure that we were covering someone from with a Christian conciliation background, that we would also have a rabbi, and we'd also have an imam. And so I would invite down Rabbi Neil Blumofe and Imam Bakash, and then also Kyle Sears, who is a Christian conciliator. And this is going to be, I think, moderated by Judge Garcia. Are you going to be the moderator for that? And without further ado, I'll turn this over.
Okay, so I'm trying to figure out the best way to do this, all together or one at a time. We don't really have a table. I guess I would ask you to first, for a few minutes, come up and tell the rest of us what you do, who you are first, what you do in your day-to-day lives, and whether or not you've been involved in faith-based dispute processes in your faith.
Good afternoon, everyone. So glad to be together, and I give my gratitude to the organizers of the seminar, and thank you very much for your interest as we try to frame this particular dialogue for the citizens of Texas. My name is Rabbi Neil Blumofe. I live here in Austin, Texas. I'm the senior rabbi of a congregation called Agudas Achim. It's a congregation that's been around for over 100 years. I haven't been there that long. I've only been there 18 years. And I'm originally from the Midwest and lived in New York and New Orleans for a while. And I've been here in Texas. My congregation is about 700 families. So there's a lot of, the age range is from obviously newborn through the nonagenarians. Lots of different folks who have different aspects of life. Many people native Texans, a lot of folks coming from different places. And I do a lot of things day to day. And one of the major things I do is a lot of counseling, and counseling can lead to mediation as well. In Hebrew, you might have sheets in front of you as well, the court system that we've had in Judaism is called a Beit Din, B-E-I-T, second word D-I-N, and that's of justice. And how does Jewish law and how does Judaism respond to various aspects both of agreement and disagreement within Judaism? Now, I'm happy to do that now, or if,
Yeah, go ahead.
Okay, great. So perhaps the most common area for when a Beit Din assembles, and there are essentially 3 members of a Beit Din, and this is, has its source in the Hebrew Bible, what some might call the Old Testament, as well as secondary literature after our primary sacred texts, which is that people get together, hear from different sides of and different perspectives, and then try to bring mediation, bring a sense of satisfaction or mutual dissatisfaction, really, to the parties involved. And perhaps the most common way that we apply this ancient custom that has been practiced continuously within Judaism is probably in the best of sense when somebody chooses Judaism, when somebody converts to Judaism. So that's not much controversy there. And when people come and they come before a Beit Din to be asked questions, perhaps the second, which is probably more germane to where we are today, is through Jewish divorce. And much of administering a Jewish writ of divorce called a get, G-E-T, just happens to be what it's called, comes nowadays through this Beit Din system. And I can talk for years, and we have this room till what, tomorrow? No. So I can speak for a while, but what I do want to do is I want to tell you across the denominational board of Judaism, whether you're Orthodox Jew or a conservative or a Reform or whatever, if one practices this idea of Beit Din or going to a Jewish court to find justice, there is a principle that is across all denominational lines, which I'd like you to know. I'll do it in Aramaic, but then I'll tell you what it means. Is that okay with everybody? The concept is called Dina de Malchuta Dina. And that is very, very important because it says that the law of the land is the law. The law of the land is the law. So it in no way can a Beit Din contravene some sort of state or national statute that's on the books. The ways that is done and the way that is sort of found together can be found in your packet that you have in front of you, where, for example, prenuptial agreements or divorce decrees can be embedded within civil decrees themselves. But there is no way consistent with Jewish law that dates back to the Middle Ages and beyond, where Jews as citizens of a particular state would trump or preempt any sort of state, national, or local way of doing business. And in fact, I do a lot of weddings too, which is fantastic. Mazel tov, great. The idea is that I don't do a Jewish wedding without a civil document as well. And that is fulfilling this idea of Dina de Malchuta Dina, that the law of the land is the law. Much, and I'll just end with this for a second, but the point where the Beit Din comes in handy most is what you might call small claims court. When people have disagreements with each other, or when folks are sort of bickering but agree to disagree, or agree to at least go to arbitration. So in those cases, when one would sign off and say, we pledge to honor the decision of the Beit Din, and if you take people's word or take people's signatures, then the Beit Din would be assembled to deal with some sort of domestic issue, some sort of child issue, and if it's kept within house of a synagogue or a Jewish community, that's great. If, for whatever reason, even after signing that idea that the Beit Din's decision is final, and I would be a member of the Beit Din as the rabbi, and I would choose myself who else would be part of the Beit Din, even if it's agreed to, the parties still have the option of going to the civil court system or the criminal court system, if you will, and the Beit Din has no power to sort of say, well, we decided already. Again, I just want to be very clear. The Dina de Malchuta Dina rules what we do. The fact that we're proud citizens of Texas and of America is a beautiful way of sort of, in tandem, realizing the beauty of how a sacred tradition and how a civil tradition can coexist. And it has coexisted for hundreds of years here, and in various aspects it's coexisted in other countries where Jews have lived. And while the Beit Din is a very important system and is a system within ritual, it is certainly not a system to be the final arbiter of issues of justice that need to go to the court system.
I did have one question. question. How are the rights of parties protected by the rules or traditions of your dispute resolution processes?
It would be based on the agreements of the parties involved of honoring that what the Beit Din was doing was actually amenable to their ideas, that there would not be a sense of injustice within the Beit Din, and perhaps in different scenarios, even though I would be able to formulate the folks who are on the Beit Din, that would be done with the inclusion and the participation of the parties as well.
So you have to have agreement of the parties
Mhm.
for the final result to be.
You have to have agreement of the people who are sitting on the Beit Din, of the 3 people. So if they come to me, I'm assuming that as their rabbi, they're going to appreciate what I have to say, and then working with them, or agents that they have, of putting together a group of 3 of whom they would trust the judgment.
Judge, would you step a little closer to the microphone? so
Sorry.
I can pick you
So-
up over here as well?
The question I asked, it was the protection for the parties. And so what you're saying is they agree to the process.
Right, primarily it would be because they would agree and accede to those who are sitting on the Beit Din.
And so what kinds of resolutions would come from this process?
Anything, again, there are ones that are more ceremonial, which have to do with converting to Judaism, and then there are the ones that would have to be of giving a divorce that's consistent. Again, a Jewish divorce is not given without a civil decree already gained. So that's very clear. So there's no such thing to be divorced Jewishly and not divorced civilly. Again, applying that principle that I told you, that the state's law is the law. So in my case, where I've seen it many times, is in, again, sort of domestic disputes about children, disputes about behaviors, things that would be kept sort of, that wouldn't really be even on a small claims issue, but would be on a particular issue of people caring what their community thought about who they were and how they enacted their business.
Are there any other types of non-family disputes y'all handle?
Certainly, there's business disputes as well. If 2 people got into a disagreement of some sort and wanted to sort of figure that out according to the Jewish traditions, that would be something that we would handle as well.
Rabbi, one question.
You have a big voice, it's nice.
Those have been provided to everyone. In terms of policies and procedures, could you talk about that? Because it seems that you have rules and procedures that would also help protect individuals, because the same rules and procedures I assume, are followed in every meeting of the Beit Din.
Mm-hmm. So does everybody have the Beit Din rules and procedures packet? Yes, no, maybe so?
Yes.
Okay, beautiful. So as you can see, there's a lot of various aspects. The Beit Din of America is an Orthodox denomination which has their own system of Batei Din, or Jewish courts. I represent the conservative congregations and the conservative movement, which would have something similar. But you can see sort of on these particular pages of who is designated to be an arbiter, how they're chosen, and et cetera, of how a Beit Din formulates and works, and how the law is decided too, which, as you say, is consistent pretty much in all of the different ways of being a Beit Din. So if you read this, which I would encourage you to do so, this is a very good understanding of how a traditional Beit Din would be done. Now, I can't speak in Judaism, you don't speak for anybody, but I certainly can't speak for other systems of Batei Din or Beit Dins that have been assembled, that may or may not adhere to all of this. But again, if it's going to count in Judaism, there's a lot of sort of deliberation that's done, and that's done beautifully in this particular packet.
So the last question I have is, if the law of the land is the law, what does this process add? Why not just file a lawsuit in a Texas court?
It's a good question, and certainly in our litigious society, a lot of people do believe that that's the case. However, I think that the caseload of our legal system is, you would speak about this better than I, but I think it's pretty taxing. And I think that as one sort of strives to live their religious life, their spiritual life as a Jewish person, one can realize that it's not just about so-called spirituality, that this idea of how to live within a particular community is very important. And in many cases, and I don't know about you, but certainly as a rabbi, I see this, that people's concern about the opinions that people have of them in their own community actually far outweigh whatever monetary settlement that they might have. So that would be another inducement for people to actually find and figure out the ways of going forward based on a religious tradition and based on the community that they're actually living in. So for me, I would see it as a savings for the legal system, too much to be put on the legal system. And in many cases, it is not an all or nothing proposition. It's that people have grievances or disagreements to air out, and they want to do it in a place that they trust without necessarily going in a way that is much more difficult, onerous, and, let me say, expensive.
Anything else? Are there any questions? Okay.
Do you think it would be fair to say that your process allows you to value other ethics rather than strictly the legal portion of it, and that's incredibly a valuable concept?
I think thank you.
Can you repeat the question?
Sure.
No, you,
Sure.
since you're.
I don't know your name, sir.
Judge Henry.
Judge Henry. So Judge Henry asked, are there other concepts that sort of feed into a legal decision that would also be important and taken up by the Beit Din? Would that be a fair assessment, sir?
Yes, sir.
Beautiful. And the answer is yes. That certainly as a counselor, as someone who sees people in their the highest points of their life and in their most vulnerable points of their life, that it's not a linear system. That there are various aspects that lead to the decision making that are actually part of who they are as a person, other experiences they've had with other with other rabbis or other Jewish communities that sort of go into this idea. And just like William Faulkner said back in the day, the past is never even past. So people who have particular decisions to be made realize that it is not just, well, the law says X. So again, the idea within Judaism is that it's the questions that matter much more than the answers. So people are, back to your point, I think, people are not coming to a Beit Din for an answer necessarily. They're coming to a Beit Din to be able to be heard, to be able to be valued, and to be able to see that their claims have legitimacy, even if ultimately they don't get everything that they're seeking. And that has everything to do with the social, environmental, and communal aspects of things that in this particular system, this particular legal ecosystem, matter as much as the legal decision. Thank you. Other questions? I guess the only other point that I would make is that ideally a Beit Din is comprised of rabbis. In Austin, there's not a huge list of those. So we choose people who are both either rabbis or well-versed or conversant in Jewish law based on the particular issue that would be. For example, if it was something regarding divorce or family, we would choose certainly family law lawyers who would be members of my congregation who would be able to sort of live in both worlds, as it were. So it's not just like hiring whoever, or and these are people who would volunteer on behalf of the community. And community matters very, very much. And the opportunity to stand tall in one's community and be able to affect a change or affect a relationship, a stronger relationship in community, I think is the best motive and the best value of a Beit Din in our society in the 21st century.